Let's bring in our think tank to talk about this radical Supreme Court decision. We have joining us a couple of great guests tonight. Corey Yeager is a former police officer, but has been a criminal defense attorney for a number of years at Koenig Yeager. Great to see you, Corey.
Good to meet you.
Also, Lawrence Zimmerman from our dream team, criminal defense attorney up in Cobb. Let me start with this. You're a former police officer, okay? With this decision and what it means, is it going to make it easier or more difficult for police officers to enforce our DUI laws?
I don't think it's really going to change how police officers enforce the DUI laws. What it's going to do is it's going to require an analysis from the courts on whether, based on the totality of all the circumstances, the police compelled a breath test in this kind of situation.
So, and what you're saying, they're compelled. I mean, isn't that the basis for all DUI enforcement, is getting that breath test? And people are going to refuse now, Lawrence, aren't they?
Well, no, Vinny. First, to your question, this isn't radical. This is the Georgia Supreme Court, which is a very conservative court. And think opinions, the court went through pains to talk about strict interpretation of the Constitution. Think Justice Scalia, Gorsuch, Alito from the U.S. Supreme Court. That's what this was about. They are interpreting the Georgia Constitution that if you force someone to do something, reading the implied consent statute is not compellable.
But isn't the whole point of it that, hey, we give you your license to drive, which isn't a right, but it's a privilege. And in exchange for that privilege, you, if you get pulled over on suspicion of DUI, have to submit to a breathalyzer so we know if you're drunk or not.
Right, but what the court did today was they did not change the fact that the states, and almost all of the states do this, they can administratively give you penalties. They can take your driver's license, that privilege. But what they can't do is they can't do an end run around the Constitution and compel you to do an act. And blowing into a breath test machine isn't just a mere exhalation of breath. You have to blow into that machine for several seconds for it to register. And that's what was the issue at bar today.
So what's the alternative?
Well, listen, police officers could still get breath tests. They just have to make sure, it's called totality of circumstance, to understand the person who's being the suspect knows that this is voluntary. And the Georgia Constitution, that's where we're sort of not understanding here. The Georgia Constitution, Vinny.
Voluntary meaning you don't have to do it.
Correct. You have to understand that you don't have to do it. But the Georgia Constitution says you can't be compelled to commit an act. So that's where the difference is here. The Georgia Constitution says it. So the Supreme Court has read that in a very narrow, conservative interpretation.
Let me ask you this, though. Are more people going to be found not guilty or less people found not guilty because of this ruling?
I don't think this ruling is going to change how many people are found not guilty. What it's going to change is it's going to tell police officers that you can't coerce folks. You have to look at all the totality of the circumstances. You have to read that implied consent notice and read it verbatim. And you have to not act in a way that would cause a reasonable person to feel that they were coerced. And that doesn't change what the law has been since at least 1999 when I became a police officer.
So this is forcing police officers to do their job more concretely or more...
It's an added step. I mean, it's like Miranda. The Miranda warnings police officers give, it's sort of, being the Miranda telling them, you don't have to take this, but it will be used against you. But by the way, the Georgia Constitution says that you don't have to be compelled to do something. But by the way, how old are you? Where'd you go to school? I mean, stuff like that to make them understand what's going on. And so the police officer knows that it's voluntary on their part. And Corey's right. It doesn't change much. It's just a couple added steps that the police officers must take so these suspects understand their rights, and then everything's good from there.
Well, let's be honest now. If anyone knows that it's voluntary and you know you've been drinking, you're not going to blow into the breathalyzer, right?
No, Vinny, because it doesn't change. The refusal law is still a refusal law, so you can still lose your license for a year. So you still have to worry about that civil penalty. This is the criminal side of it.
So do you think this will make our roads safer or less safe?
I don't think it's going to change whether the roads are safer or less safe. All it's going to do is to make sure that police officers follow the Constitution of the state. And this is not something that's new. This law and this interpretation of the law goes all the way back to 1879.
All right, let me finish this now. So I'm getting what you're saying. You're saying this is a constitutional argument. Can you concede, and will either of you concede as criminal defense attorneys, that this is much better for you than it is for the prosecutors?
Well, I think it is better for us than the prosecutors in that the court has not created some magical DUI exception to the Constitution. They've said even in DUI cases, we have a Constitution. You, the state, are required to follow it. And there's nothing inappropriate about that. The state should follow its Constitution.
And will defense attorneys now across our state tell people, whatever you do, don't blow into that breathalyzer, because you don't have to?
Well, you don't have to. But the same administrative penalty that was there before this case is still there. And that is, if you refuse to submit to the testing, you're going to potentially lose your driver's license for 1 year. Now, there have been some changes in the administrative law as well, but realistically, what you run the chance of is losing your driver's license. And that is a civil penalty that the United States Supreme Court, and that is a civil penalty that the Georgia courts have found is appropriate.
But what happens at that scene when someone refuses to blow into the breathalyzer?
Well, the police officer's got a couple of choices, right? He can take that refusal, which in and of itself can be used as evidence, or he can go one step further. He can go down and take the person before a neutrally detached magistrate, a judge, and he can get a search warrant. And Georgia's code section says that even after you refuse, they can still go get that warrant. So it doesn't preclude them from getting their evidence. It just requires them, simply put, to follow the Constitution.
But Lawrence, if the clock is ticking, right, and we're talking about a blood alcohol content, the longer it takes to get that test and those results, the more room you as a defense attorney have to dispute those results, right?
Well, it's not necessarily, because for blood, it doesn't dissipate as fast as it does for taking a breath test. But this isn't about me as a defense lawyer. This is about Georgia citizens and the Constitution. And the Supreme Court is saying this must be done to protect you, the suspect, when you are pulled over for DUI. This has nothing to do with us lawyers. I get we may be able to work around this, maybe help our clients a little bit more. But this is about the Constitution. The Supreme Court has made that ruling.
But doesn't this just help the drunk citizens and not the sober citizens?
You know, that's the same police officer, the same argument that police officers use until they become a suspect, until they're involved in a deadly physical force situation, or until they're involved in something personally. And the first person they're going to call is a defense attorney to protect their rights using that same Constitution. So does it protect the drunk driver? Yeah, it protects them. It gives them the same constitutional protections that everyone else gets. It doesn't give them more.
Why should we be protecting drunk drivers?
Because they are citizens of the state. And what this does is it makes sure that the state, the government, follows the rules before they take away your liberty and your privileges.
But you're not just protecting drunk drivers. You're protecting every single one of us, because there's plenty of people that could be falsely accused. You guys did a story a month and a half ago about how police officers pulling over people accusing them of marijuana, and there's no such thing. You guys did a whole piece on that for a month. So you as a citizen have a right to refuse the government's intrusiveness. Let them go get a warrant. That's all you're doing. That's what the framers intended by the Constitution. That's what Georgia is saying. This isn't protecting drunk drivers. This protects every single one of us. When this drunk driver's case may get kicked because the Constitution is violated, it tells the police that next time they better follow the law, because it may be you who's innocent, but follow the law, do it right, and that's the issue.
But what do you say to the parents of somebody who's lost their child because of a drunk driving accident?
I'm not here to talk about, what am I going to say to a drunk, sorry, your child died. That's something terrible. This is an issue about the Constitution. That has nothing, that is apples and oranges. And excuse me, it's just a different situation.
Well, we appreciate your input. I know you guys have a tough job, but it's what keeps our Constitution working. We appreciate it, Corey and Lawrence. Thank you so much.
Thank you as always.